Good morning. Are you Lacey Bork?
Yeah.
And this is 25 DCCR 1213. Mr. Bork is charged with the state jail felony offense, excuse me, of theft of property. That indictment alleges 3 prior state jail felonies from different dates, which means for punishment purposes, this could be considered a third-degree felony with a punishment range of between 2 years and up to 10 years. And Mr. Lewis, what is the announcement?
Judge, initially came in planning to place this on the trial docket, but after speaking with Mr. Bullock this morning, I guess after his conversation with his family, they'll be able to retain his own attorney.
Okay.
So I asked that he have at least have that opportunity, at least one setting before the case is placed on the trial.
So, Mr. Bork, I'll reset your case to normal reset, which is about 30 days. Mr. Lewis is going to remain as your attorney, unless you get someone else hired. If you do, they'll file the appropriate paperwork to substitute in for him. If for some reason that doesn't happen before the next court date, then we'll need to go forward with you visiting with Mr. Lewis and see where we get on your case, okay?
Yes, ma'am. Can I ask a question?
What's that?
My time wouldn't go up. I mean, I should be able to get a lawyer, but my time wouldn't go up like I'm playing with you or nothing like that.
No, there's been no reduction.
The offer is what the offer is. It's probably,
Okay.
it's not going up or down at this point for any reason. If he wants to get his own attorney, he has that right. I'm not
Okay.
holding that against him.
Sure.
Thanks.
So that'll remain on the table. That's between y'all at this point. Once there's a rejection later in front of me, then things kind of change as far as accepting plea agreements later. But it sounds like Mr. Nichols is going to leave that on the table for you. Okay? All right. You can go back with the bailiff. Thank you, Mr. Nichols.
And Judge,
Yes.
while we have Mr. Nichols up here, we had the Antonio Riggs on the docket.
Uh-huh.
And before he's brought up, I wanted to speak with you about him. We definitely have a competency issue with him.
Just to fill you in, he was found competent back like in February.
Mm-hmm.
Mr. Lewis has informed me as he seems to have deteriorated some. I checked his jail screen. He has a history of seizures and things like that also affect him. So I think he probably
We need a new evaluation.
Yeah, and his family's here. They've come into speaking with me as was their interactions with him over this time.
Okay.
He's definitely deteriorated, got scattered.
Okay. I'll reset the case. If you'll make a notation for us to do the order for an evaluation on Mr. Riggs, please. And
Yes, no.
and just make a notation. We could even do
Sorry.
whichever one we didn't use. Use that other. Okay. Thanks. You can we're gonna reset Mr. Riggs. And then you've got Christopher Fair.
Yes.
Good morning. Are you Carl Farrow?
Yes.
This is 26 DCCR 0100. Mr. Farrow is charged with the state jail felony offense of unlawful possession of certain copper or brass material from October 30th of 2025. And what is the announcement?
Your Honor, if we can get a little bit more time, I've met with Mr. Farrow. This case involves whether he had authorization to possess these copper materials, and he's relayed to me that he does have documentation that had given him the authorization. And so if we could have some time so that he could get that to me.
Okay.
Yes.
All right. So I'm going to do a normal reset, Mr. Farrow. Make sure whatever information you have, you get that, or your family or someone gets that to Ms. Holmes as quickly as possible so that she can then visit with Mr. Smith about it and then be back out to visit with you before that court date.
Thank you.
All right. You can go back with the bailiff. Donnie Smith. Donnie Smith. What?
We got bond reduction?
This isn't how we communicate. It's for me because it's a bond forfeit. I now have to say out loud, and make certain findings if they've had previous bond forfeitures, if they end up playing in sentencing. So I have to have them now look up that on everybody. Mm-mm. If they're really not really like leading up to the docket, then yes, you have to go back and look and they can tell you about that. Good morning. Are you Donnie Glenn Smith?
Yes, ma'am.
And this is cause number 26 DCCR 0072. Mr. Smith is charged with assault on a peace officer. And what is the announcement?
Well, Your Honor, he had previously pled, but he didn't appear for his sentencing.
Oh,
And so,
okay.
yes, ma'am. So we had done all that, but he didn't appear.
He pled, Judge, but there was no agreement as to the type of probation.
Do you
Or
have
The
a-
type and.
anytime.
Is there a PSI? It shows a status hearing, but I should have, it was set for sentencing and he didn't show up, and so there was a bond forfeiture. So I should have a PSI on Donnie Smith. It's
If you
not in the
don't mind.
case.
I've got two
No,
copies.
because I'll have notes and,
Okay.
all right, just, y'all can hold him for a few minutes. Let me, figure out where that is.
Yeah.
Good morning. Are you John McMillan?
Yes, I am.
And this is cause number 26 DCCR 0517. I'm going to take judicial notice of the court's file. There was a request and Mr. McMillan was evaluated for competency to stand trial. Dr. Krapon provided a report dated May 29th of 2026 with the finding in it that Mr. McMillan is currently competent to stand trial. Any other evidence with regard to competency?
No, Your Honor.
No.
All right, then at this time, I am going to find Mr. McMillan competent to stand trial, and Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Judge, with the court's permission, we proceed on a lesser included Class A assault on this, just so the court knows I have sent multiple letters with lack of response. That's the reason for the law.
All right, thank you. So, Mr. McMillan. Again, in cause number 26, DCCR 0517, the state's elected to proceed on the lesser included offense of a Class A misdemeanor assault. And that's from March 8th of 2026. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. All right, Mr. McMillan, I'm going to find that you entered your plea of guilty freely and voluntarily. Again, I made that finding already that you're competent to stand trial and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A.
Today's docket reminds us that no two courtroom cases are ever the same. Some defendants ask for another chance, others accept responsibility, while some face questions about their ability to stand trial. Behind every case is a different legal challenge, but the goal remains the same: ensuring justice is carried out fairly under the law. Which hearing stood out to you the most? Let us know in the comments, and subscribe for more real courtroom stories and legal breakdowns.